This podcast episode reflects the opinions of the hosts and guests and not of Greenberg Traurig LLP. This episode is presented for informational purposes only, and it is not intended to be construed or used as general legal advice nor a solicitation of any type.
Welcome to our inaugural episode of DC Everywhere, a mini-series on Greenberg Traurig's Big Law Redefined podcast about the people and practices that help clients navigate Washington, D.C. I'm your host, Tonya Esposito. I'm the administrative shareholder in the Washington, D.C. office, and I am also co-chair of the firm's Global Antitrust Litigation and Competition Regulation practice. I'm here today with my co-chair, Bill Katz, who's based in Dallas, but also spends a fair amount of time in Washington, as well as Justin Hedge, shareholder also in the Washington, D.C. office in the antitrust group. And we're going to dive into some antitrust trends and topics that are at the top of clients' minds, but might not be the headline-grabbing items you're thinking of. So let's go ahead and get started. I would love to start, Bill, with you and ask you to take a few minutes and tell us about your practice and who you are.
Yeah, thanks, Tanya. I'd love to do that. Obviously, as you said, you and I help run the antitrust group here at Greenberg. My practice focuses primarily on antitrust litigation. So I'd say I probably spend 75 to 80% of my time focusing on antitrust litigation. So in large part, that is class action defense. So we're handling a couple of larger MDL cases, but also we do find ourselves oftentimes defending non-class action related antitrust cases. And sometimes it also means that we might find ourselves on the plaintiff side if we have clients who feel like they've been harmed or excluded from a market from a competitor. So that takes up most of my time on the litigation side. And then I'd say the remainder of my time is focused on counseling issues, and that could be related to a potential transaction, M&A type activity, joint ventures, the formation of joint ventures, how to do that in a way to minimize antitrust risks, or it's related to compliance or conduct issues. So it could be helping a client put together an antitrust compliance policy, train employees and how to comply with antitrust related issues. Oftentimes we represent some clients who participate in trade associations and kind of the do's and don'ts of that kind of activity, as well as other types of kind of pricing conduct in terms of what they can and can't do with respect to setting prices or communicating with others related to their pricing, or what kind of software or other types of outside information can they rely upon in order to set their pricing. That's kind of a quick overview of who I am and what I do here.
Excellent. Thank you for that, Bill. And now I'd like to hand it over to Justin to do the same. Tell us a little bit about your practice and who you are.
Yeah, thanks, Tanya. Happy to be here with you. I practice primarily in front of the DOJ and the FTC doing antitrust investigations work. That's anywhere from conduct investigations to merger investigations. What I think is really fun about my practice is I'm really helping companies to build out and execute on their strategies. So when they're coming up with organic new product ideas, I'm working with them through, can we do joint development on this? Can we do joint manufacturing arrangements? What are the antitrust considerations when we're doing that with a competitor? How do we build out a new distribution network and pricing and loyalty programs? Working through all of those, which can be tricky. And also, if you do it the wrong way, then later subject to a government investigation. And then I spend a lot of my time as well on merger investigations. So identifying and managing antitrust risk during negotiation of purchase agreements, and then defending those mergers all the way through the HSR Act notification and review process. And I manage multi-jurisdictional deals, right? Because so many of our clients are across borders and each jurisdiction has its own merger regime. It can get pretty complicated pretty quick. So I do that across a ton of different industries, which is really neat and fun, right? Really seeing how all the different sectors of the economy are operating, from retail and consumer products, energy, manufacturing, technology. So that's really my sweet spot and what I love doing.
Excellent. Thanks for that. Wanted to move to some merger enforcement trends, and you just told us that that's a big part of your practice, merger counseling and all the things that go along with it. Curious to know whether in your practice you've seen any trends of late or things happening either at the federal level, the state level that would be interesting to talk about and give our audience a little peek into what we see coming down the pike?
Definitely some changes have happened with the administration. I would say antitrust historically has been pretty even keeled, but now it's the policy choices are becoming more lopsided depending on where you are in a political cycle, sort of big shifts up and down in terms of enforcement priorities. Right now, I think we're seeing faster timelines on reviews, more openness to negotiated outcomes. The end of the last administration, there were a lot of lengthy investigations, a lot of second request investigations, right? So just by way of background, there's an initial HSR Act filing that gets the government the chance to review these mergers before closing. And if in the first 30 days, they decide there's something here that concerns us that we don't understand enough about, they can launch into the second request investigation. And at the end of the last administration, we were seeing a ton of deals getting investigated. And more problematic to parties was there wasn't any kind of engagement on settlements. So cases either folded under time and financing pressures, or they had to go to litigation. And that takes a long time at a lot of expense. So now we are seeing a return to the government being willing to settle cases to find the right solution. It's been a huge policy shift because the reason we didn't see that before was the stated rationale, at least, was that the government shouldn't be in the business of deciding what the right kind of settlement, the right divestiture should be. Because if we get it wrong, the deal's already passed and consumers are potentially worse off. And now the shift is to more, look, M&A is part of the natural innovation cycle, right? You can't have people investing in startups if there's no exit. So we recognize that that's part of the economy and things that need to happen. How do we find a way to balance the competitive interests, making sure that we have a competitive economy while still allowing M&A to go through as it needs to? And so that's why the current administration, at least that's what they're saying in their public statements, that's why they've really returned to considering and rolling up their sleeves with the parties to try to figure out a negotiated solution in a lot of cases that work. I think that's sort of the biggest shift that we've seen sort of right out of the gate in the first few months here.
Any particular industries or sectors that you think are interesting to this administration?
Yeah, they obviously care about competition across the whole economy. We've seen the second request investigations get issued in a range of industries already, from analytics and software, semiconductor manufacturing, self-checkout technology, medical devices. So they are looking hard, I think, across different industries. That said, again, getting back to my earlier point that we're seeing sort of quicker timelines, some parties are able to resolve concerns quicker without an in-depth investigation. We've seen in a number of different industries already, parties have been able to do what's called a pull and refile, which means you voluntarily restart that initial 30-day period if there's some questions that the government has, but it seems like there are questions that can be answered quickly. And so we've seen a number of deals in a number of industries get resolved that way. Where I think the focus really is a lot still in healthcare. The two deals that the current administration has actually taken to litigation since the change over in January are both medical device transactions. One, we just saw the FTC actually lost this week. But again, that still takes the parties a long time to get there. But I think healthcare is always going to be one that the government cares about, and that continues to be true in this administration.
Any thoughts on staffing or resources? Have you seen any effect in sort of the changes that have occurred at the regulators? Has that had any effect on your practice?
I think it's always a question for them of resource allocation, right? And right now we are at a peak for monopolization cases that the government is bringing against a number of technology firms in particular, but also other companies. And that taking those cases through trial is very intense in terms of resources and often requires even hiring outside economists to experts. And that's a drain on the budget, not just the existing staff and their time. So I think that that's going to continue to be a focus because I think these are issues that the administration is committed to. I think it's a practical reality then that drawing some resources away from the merger investigations or other types of conduct investigations. Yeah, I think inherently it has to. But like I said, that doesn't mean that they're turning a blind eye to real significant problems.
Got it. That's helpful insight. Let's shift over to Bill and talk a little bit about litigation. Bill, you and I are obviously both antitrust litigators and work on matters together, but interested to get your take on any trends that you're seeing on the litigation front and thoughts you might have there.
I would say the overall trend is that antitrust litigation remains a hot area. I think the interesting thing that I've sort of seen throughout the course of my career is how sophisticated and good the antitrust plaintiffs bar has gotten at identifying cases. Like earlier in my career, it used to be that they would tag along after there was like a DOJ criminal investigation or an FTC investigation or stuff like that. And now what's really interesting is that the level of sophistication on the plaintiff side is that they're actually out in front. One specific recent one where the plaintiff's class action bar is out in front bringing claims. And then what you find is that DOJ or FTC might follow up on that. So I think the short answer is it remains strong and robust. And we've certainly seen that in our practices and here at the firm. I would say there are a couple of trends that are probably worth kind of noting, I think. Algorithmic price fixing or using some type of software or AI, that remains a hot button issue. We now have a whole series of cases across a wide range of industries where the plaintiffs seem to be figuring out, okay, we started with multifamily housing and student housing. Let's now move on to hotels. Let's move on to mobile homes. Let's move on to kind of healthcare and insurance markets and things like that. And so I think what they've sort of found is this kind of a cottage industry where you can take some of the same type of arguments as to why certain types of conduct is allegedly anti-competitive, and then they just kind of hop from one industry to another, bringing those types of cases. I think definitely one of the things that obviously it's on our radar here is kind of seeing how those cases shake out. I think at this point, when you look at those cases, it's a bit of a mixed bag for the plaintiffs. They've got some claims that are survived motions to dismiss, but on the other hand, you have other instances where the cases have not made it past the motion to dismiss stage. And even one of those cases was recently, I believe, affirmed on appeal from appellate court. So I think they're trying to find kind of that good facts and a good case where they can try and kind of break through on some of the stuff. It's similar to what Justin was saying, just like the government has a lot of resources, they're not unlimited when they're picking and choosing enforcement actions and what deals to challenge. Same thing. The plaintiff's bar has a lot of resources, but it's not unlimited. And they're trying to kind of find the good test case to kind of get over the hump of dismissal, get to discovery, and then try and make some good new law out there, at least from one perspective. I'd also mention, besides the algorithmic price fixing cases, other things that we've kind of seen is a lot of hub and spoke conspiracy issues. That those come up both in the algorithmic price fixing cases, but I think what we've seen in our own practices is that even going back to suing trade associations and trade association members related to trade association conduct, which again, it's not inherently anti-competitive right off the start. And there's a lot of really great things that trade associations do, but there's a lot of issues related to that. So I'd say some of those issues have been really, really prevalent, particularly on the class action side. Obviously, as Justin said, from an industry perspective on the litigation side, I think it's sort of similar to kind of what you've seen on the enforcement side or the transactional side. The technology industry, it's such a huge part of the country. It's just something that people touch literally every day and literally like physically touch with their phones or otherwise, right? I mean, that's a hot industry for antitrust litigation, both in the private sector as well as the government enforcers. And I also think like healthcare, there's a whole bunch of healthcare cases on a variety of issues. So I'd sort of say that to sum all of that up is antitrust litigation has been strong and for a while. And I would sort of expect that to continue. And it's gotten to the point where it almost doesn't necessarily change. I mean, it ebbs and flows a little bit, but it doesn't necessarily ebb and flow when you have like a new presidential administration, for example, or it doesn't necessarily ebb and flow based upon what the government enforcers are doing. The last thing I'd kind of want to mention, and this probably I think holds true even for sort of Justin's kind of practice as well as like what you and I do, Tonya, is also kind of watching how the states on the antitrust enforcement side have gotten much more aggressive in that they're bringing their own cases. They're certainly joining in with the federal enforcers, but not even afraid to bring their own cases and make their own challenges on certain things So that's been kind of an interesting trend that's kind of prevailed for several years now. And again, I would expect that to continue in the future.
Thanks for that, Bill. That got me to thinking. I know that, Bill, you and I recently individually joined our colleagues in Mexico City on their competition podcast to talk about trends and compliance and some things from their perspective. And we had a nice conversation around what we're seeing more globally on the competition front. And just curious to know whether both you, Bill, and Justin have thoughts on the global landscape in this administration and what we might be looking at going forward. I know in prior administrations, there had been varying amount of cooperation, but certainly cooperation between the United States and other competition authorities. So just curious to get your thoughts on whether there's anything we should keep on our radar on the global front.
It's interesting. I think the modern trend, if you will, is for more collaboration. And to a certain extent, I think that benefits parties because, look, you're making the same pro-competitive arguments in the different jurisdictions. Why not have those folks talking to each other to move the entire process along efficiently? That said, in the last administration, there was a few instances that drew public criticism where folks had the perception, at least, that where the U.S. authorities thought they maybe couldn't reach certain deals because in the U.S. the system is designed, you have to go to court and you have to convince a neutral and detached magistrate that the deal is anti-competitive. So the government has the burden. In other jurisdictions outside the U.S., they're more of a regulator. And so the competition authority itself can make the decision about whether or not to approve the deal. And so the criticism that came up was, did the U.S. authorities go to some other jurisdictions and sort of help them along or encourage them to bring cases that maybe they thought they couldn't really make out under U.S. law? And was that really appropriate? That at least was the criticism. Now what we're seeing in a recent speech by one of the FTC commissioners, she sort of said, look, we're only going to cooperate to the extent it dovetails with what's anti-competitive under U.S. law, sort of signaling that if we don't think there's a case under U.S. law, we're not really going to be using our resources in that sort of international cooperation environment, right? If we're done in the U.S., we're done, and they're out. That, I think, is an interesting shift. One comment I want to go back to, though, on the state side that Bill mentioned, we definitely see cooperation with the states. I think states have always brought their own actions. They always have issues that they feel maybe strongly about that they felt like the federal enforcers came out differently on. And so states have brought their own merger cases in the past. One of the two cases that I mentioned in the healthcare space that have gone to litigation, 2 states joined in one of those. So they still cooperate with the feds. We are seeing those states start to adopt their own merger reporting regimes under a uniform pre-merger notification bill that's circulated. And so what that does is states are going to their legislatures and saying, hey, get us a copy of the information that's provided to the federal authorities during that pre-closing period so that we can review these deals in real time with the feds and not be reliant on having to issue our own CIDs to get information out of the parties. So Washington and Colorado, this summer, their laws came into effect that now require in certain cases, if you have a nexus to those states at the deal, you have to give a copy of the HSR Act filing to those state AG offices as well. I don't think yet. I think it's too early to tell if that's really going to result in more state-specific enforcement. But certainly now they're getting information faster than they might have under sort of the way things used to work. So only time will tell. But I think we're still seeing a lot of state activity as well as coordination with the feds.
Thanks for that, Justin. Bill, any thought on the litigation or compliance side?
I agree with Justin saying, I mean, the current enforcement, at least at the federal level, has sort of definitely been, say, more of a kind of a pullback to what I think the current administration would view as kind of the appropriate level of enforcement without sort of what they would probably describe as overreach and stuff like that. So I would say what to me has sort of been interesting, and again, I think you still will certainly see coordination among the at the federal state level or the US and other countries. But to the extent that folks were sort of speculating before the new administration came in that there was going to be more of a laissez-faire approach. I mean, I don't think that's certainly held true. Obviously, there's definitely, I think, continues to be fairly robust and aggressive antitrust enforcement. Obviously, the priorities might currently maybe different than they were a year ago, but it's interesting. And I know, Tonya, you and I have talked about this, about how in a large respect, though, there is a fair amount of overlap. So, for example, healthcare markets, again, have been historically across administrations hot button areas for antitrust enforcement and litigation, and that's held true. I mean, as Justin said, that the two challenges that are kind of currently out there now are both in the healthcare space. In addition, what's sort of been interesting is the continued focus on labor markets, right? That and employment issues. Although the approach, the means of doing so is different, right? Whereas prior administration tried to do a very, very broad rule related to non-competes, for example. I think this administration is taking it more on a case-by-case basis, but still had a recent enforcement action addressing non-compete provisions and contracts and stuff like that. So there's kind of a lot of overlap at a high level of the mechanisms by which they're going about that, and whether it's more of, if you forgive the analogy, sledgehammer versus scalpel approach, right? I mean, I think this administration would view their approach as being more scalpel related and being kind of narrowly tailored rather than taking more of a broad brush approach. But there's robust coordination, no matter how you slice it, across countries or states or the federal government. And it remains robust in areas that overlap administrations like technology, healthcare, and labor and employment markets.
Agreed entirely. This has been really good to spend some time with you both. Before we wrap up, just curious if either of you have any takeaways that we might want to offer our audience about things to keep in mind or issues we might see immediately on the radar that listeners might want to pay careful attention to.
An ounce of prevention is worth a pound of cure in a lot of cases. Bill was just talking about non-competes, for example, which is one that actually dovetails with healthcare because the FTC is coming after overuse of non-competes among healthcare staffing businesses and in other healthcare settings. Going over those kinds of things gets you out of a lengthy and costly investigation. Thinking about your pricing and loyalty programs as your products do well and get market share, right? Because that's when you start to transition into monopolization concerns. So keeping pace with the business and checking in and making sure folks are aware of what the antitrust sensitivities are, I think is always a best practice. On the M&A side, now that we have an administration that is willing to consider arguments and settlements, think through in advance what would be an acceptable remedy if one's needed. And thinking through those things creatively in advance, I think can really help speed up the process, keep it to be more efficient all the way through. The other point I think I'd make is if you see something, say something, right? I mean, this is about competition. You're not always on the defensive. Sometimes you see competitors doing things that they shouldn't be doing. And the government's door is always still open for those kinds of calls about identifying new problems that people see out there in the industry to make sure the playing field is level.
Yeah, I had a question actually for you, Justin, I was kind of curious to see what you guys have been seeing with the new HSR rules that went into effect earlier this year. And are you all recommending to clients that they be more proactive, particularly if they're active in the M&A space, to try to get a lot of that additional information that's required under the new rules and have that available so that they're not scrambling as they're getting ready to make a filing to pull together all the additional information? I was kind of curious as to what you're kind of advising clients to do on that issue.
Yeah, absolutely. It's become more burdensome in that what the government has done effective back in February was asking for a lot of types of information up front that they used to only get later if they thought there was something worth investigating. So they're making more informed decisions, I guess, earlier in the process is one way to look at it. So getting ready for that. But to my earlier point of sort of an ounce of prevention can be significant. It applies to that merger context too, because we are providing now more information to the government with the initial filings, making sure that you're careful and precise in the language you use in ordinary course business documents because those are part of what has to go in now with the initial filing. You're being conscious of that and making sure that you're being clear in your internal documents is I think something that clients need to be keeping at the forefront so that they don't inadvertently have to answer questions about things they didn't intend.
Yeah, bad documents or badly worded, bad word choice, right? That will bite you both on the transactional side and the litigation side. Yeah. So to answer your question, Tonya, I think being proactive, having a good compliance policy, having a good tone at the top that antitrust compliance is important, making sure employees understand that. And like Justin said, making sure the employees understand and are mindful about the fact that the internal emails that they send today may be exhibits or in some merger litigation later, or an investigation that Justin was working on to try and get your merger cleared. So just be careful about what you say and those kind of things. I think that's very, very helpful to try and get in front of this stuff. And to the extent that there's any uncertainty, to just have folks contact an antitrust lawyer and get some advice on like, hey, I think this could be a problem here. What do you think about this? And that's on everything from what you're doing or your employees are doing, but also to the extent that you think your competitor is tilting the playing field and it's no longer level and that you feel like you're being hindered, not from competition on the merits, but because of something that could be a potential problem. And we can help provide some advice and some guidance on those issues going forward.
Yes, agreed. It's never a bad time to revisit that antitrust compliance plan and think about whether it needs an update or it's time to just sort of recirculate and make sure it's fresh in the minds of everyone in your organization. Thank you both so much for your time today. This was great. And thank everyone for joining me for this episode of DC Everywhere. We're going to be pushing more of these out, so you'll hear from myself and other folks across the GT platform who help clients navigate all the things in Washington, D.C. So thanks again for joining and hope to be with you again soon.